seek your Lordship's indulgence, Your Lordship. If I may be allowed to mention item number 4, hearing. I have taken the consent of the private respondent, Your Lordship. If this matter can come up on the 17th this month.
On the prayer made, who is for the other side?
Your Lordship,
Not
the private respondent is Mr. Valalha.
Mr. A.R. Malhotra, learned counsel for the appellant, prays that the matter may be adjourned till 17th. Full stop. He submits that he has also taken the consent of the other side. Accordingly, this is matter on 17th.
For motion, item number 1.
Yes.
Lordship, this is a matter challenging the appointment of the respondents number 3 to 36, who were initially appointed
They are
as
challenging their appointments or their
Appointment.
regularization?
yes,
Which one?
appointment on regularization. Yeah, Lordship.
So you are challenging their regularization.
Regularization.
Not their initial appointment.
Not initial appointment.
So, so
The
where
impugn-
is the regularization order?
The impugned order at page 130, Your Lordship. This is the minutes of Departmental Promotion Committee to consider regularization of 31 health workers, provisional employees, held in the office chamber of the Commissioner.
Under
And
the
so-
Government of Mizoram regularization of CSS Employee Scheme 2020.
Yes, yes. Since they were not the employees, CSS employees, they could not have been regularized under this scheme. And the impugned office order is at page 133,
133.
133, Annexure 21. They are altogether 31. Showing
They are not employees under the CSS.
they are not employees under CSS. They were initially appointed, as the Lordship may see,
No,
at page
initial, not the
94.
initial. At the time of their regularization, were they CSS employees?
No.
And what about you?
We started as CSS employees.
You started
but
as
then
CSS
yes,
employees. Then
2007, and we
then-
continued as such till date.
you are CSS employees.
Yes.
Let us see the 24 rules. Where is it? Page 102. Is it? No, this is.
Lordship, 82. Annexure 8, 82. This is a notification dated 18 June 2024. Scheme, Your Lordship, the short title and extent, commencement. The scheme may be called the Government of Mizoram Regularization Centrally Sponsored Scheme, Employee Scheme, 2024. It has come into force from the date of publication in the official gazette. And eligibility under Rule 4 at page 83, Your Lordship will see eligibility conditions for regularization. Subject to the decision of the state government as provided under Para 3, an employee under central sponsor scheme shall be eligible to be considered for regularization to a regular post under this scheme if he or she fulfills all of the following eligibility conditions, namely, A, he or she must be continuously engaged as
Have
centrally sponsored scheme.
you fulfilled these three conditions?
Yes, yes. In fact, this scheme has been made on the request and pressure made by the employees' union.
Anyway, we'll issue notice. Heard Mr. C. Lalamzawa, learned counsel for the petitioner, assisted by Ms. Amira Elmar, who submits that the impugned order dated (21/8/25), regularizing the services of the private respondents under the Government of Mizoram Regularization of Centrally Sponsored Scheme bracket CSS bracket close Employees Scheme 2024 should be set aside. The reason being that the private respondents are not CSS employees,
And are not eligible for such regularization.
while the petitioners are CSS employees who have the eligibility criteria required for regularization. Issue notice.
Even
that-
apart from that, Your Lordship, the petitioners were appointed on contract basis in the year 2007, while the private respondents were
How does it
appointed in the year
matter? How does it-
2014.
Issue notice returnable in 4 weeks. Ms.
In the meantime, Your
Linda
Lordship,
L. Fumble, additional AG, accepts notice on behalf of the respondents number.
1 to 4.
Huh?
1 to 4.
A petitioner takes steps for service of notice upon the respondents number 5, to remaining private respondents by registered post with AD within 3 days. List the matter after 4 weeks.
Lordship, I have an interim prayer for stay of the operation of the Bune order.
In the stay will not be proper. You just say the prayer of the petitioner for an interim order may be considered on the next date.
Yes, obliged.
For admission, item 2.
May it please your lordship, I am appearing on behalf of the state respondents. As per the last court order, which is on 18th of September, though the affidavit of position was already drafted and it was ready, however, there were certain changes which had to be made.
Madam, this is a 23 matter.
Yes, your lordship.
It's a small issue.
Yes, your lordship. However, certain annexures were not legible, your lordship. So that is why a typed copy had been requested, and I am yet to receive the copy of the same, your lordship.
So when will you file?
Your lordship, if I may be given at least 2 weeks' time to file the affidavit, your lordship.
You have asked for time since how long? Since the year 2024.
Yes, your lordship. However, your lordship, the matter, there were certain annexures which were incomplete or were illegible, your lordship. So I had requested time and again to have a typed copy of the same.
Last chance.
Yes, your lordship.
Ms. Lalnun Rui, learned government advocate, is granted 2 weeks' time as a last chance to file affidavit. This is the matter after 2.
For orders, item 3.
Your Lordship, I have filed my written objection this morning to the
Yes, we take
consideration.
it up. Yes. You see, I was looking at this case.
My Lord.
Now, it appears, their case is that they got to know of the airship certificate issued to you lately.
Yes.
And there is no notice issued.
Yes.
Then. And what about, you have also been given a airship certificate.
Mm.
Yes, Your Lordship.
What has happened to that airship certificate?
It is not.
Huh?
It is not yet challenged now.
Now we are about to challenge, my Lord.
You are about to
Yes.
challenge. On what ground? No notice?
No
Or what?
notice also. That
Then
one
you
also.
challenge that also. This also will, but this we will let it go. We will set aside this. There is no case. You challenge that, that also should go. Your airship also without notice.
It is not noticed, but the father was called,
Huh?
the petitioner's father was called to the court, and it appeared before the court.
Petitioner's father.
Yes.
Okay. Anyway, this case, no legs to stand on. Right. Heard, Mr. Lal Pierfel Achongtu, learned counsel for the applicant. Also heard Mr. B. Lalram Mehenga, the learned counsel for the respondent. The matter pertains to the issuance of an airship certificate in respect of land covered by LSC number 564 of 1980 in the name of Lal Rikhumi late. The applicant's case is that the respondent had applied for an airship certificate. The applicant's case is that the respondent, who is the nephew of the deceased, Lal Rikhumi late, had applied for airship certificate. Full stop. The same was granted by the which court? Same was granted
Senior Civil Judge 3.
by the court of the Senior Civil Judge 3 Aizawl
Yes.
on 10/11/2022, while airship certificate number 1551 of 22, without issuing notice to the appellant. Full stop. As the appellant came to know of the airship certificate only on 18/9/2024, and as the appellant and the applicant thereafter made a challenge to the same on 1/11/2024, a delay of 723 days. Now, how many days? A delay of 723
700.
days has occurred. Next. Mr. B. Lalram Mehenga, what do you have to say?
There is no explanation regarding how she came to know about
Sir,
the.
Mr. B. Lalram Mehenga submits that there is no explanation given by the applicant as to how she came to know of the airship certificate issued to the respondent. He also submits that the respondent is not the biological child of Lal Rikhumi late. He, however, does not deny the fact that airship certificate had been issued to the respondent without issuing notice to the applicant. Full stop. He submits that as there has been no day-to-day explanation for the delay, the application should be dismissed. Full stop. I have heard the learned counsels for the parties. On a perusal of the application for condonation of delay and the connected documents thereto, this court finds that the applicant has taken a stand that she is the adopted daughter of Lal Rikhumi late, while the respondent is the nephew of Lal Rikhumi late. Full stop. On the death of Lal Rikhumi on 5/6/2022, LSC number 564, the question to be decided is whether the land covered by LSC number 564 of 1980 should devolve upon the applicant or the respondent. In view of the fact that no notice has been issued to the applicant, who is alleged to be the adopted daughter of Lal Rikhumi, this court is of the view that keeping in view the judgment of the Supreme Court in the case of Lipokau, state of Nagaland versus Lipokau, so, there may be grave injustice if the delay is not condoned. Accordingly, the delay of 7 to 3 days is condoned. I is accordingly allowed. Then in the appeal, we'll set aside.
Yes,
There's
my
nothing. Because both of you, you go then.
Yes.
You make a challenge to his also, then it both goes. If
Yes,
there's
sir.
no notice.
Yes, Your Lordship.
We'll try it in the civil court.
Yes, you do
Yes.
that. Right. The father of who had appeared? Your father had appeared. You mean Lal Rikhumi's husband?
Yes.
Acha, he was there in the trial court
Yes. He
before
appeared.
issuing notice to you.
Yes.
Okay. Anyway,
For
right.
my years, yes.
Heard Mr. So-and-so and Mrs. So-and-so. This is an appeal against the order dated 10/11/22 passed by the Court of the Senior Civil Judge Sri Aizawl District, by which the impugned airship certificate application number 1551 of 2022 has been granted in favor of the respondent in respect of the land covered by LSC number 564 of 1980, which was in the name of Lal Rikhumi late. Next para. The appellant's case is that she is the adopted daughter of Lal Rikhumi late, and that the respondent is the nephew of Lal Rikhumi late. First up. On the death of Lal Rikhumi late on 5/6/2022, the appellant had apparently not issuing any notice to the appellant herein, who was living, you're living with her or what? You lived
Yes,
with
living
her?
with her, yes.
Who was living with Lal Rikhumi late till her death. Full stop. As no notice had been issued to the appellant by the learned trial court prior to issuing the impugned order dated 10/11/2022, this court is of the view that this court finds that the impugned order is not sustainable in law. Accordingly, the impugned order dated 10/11/2022 passed by the Court of the Senior Civil Judge Sri Aizawl in airship certificate application number 1551 of 2022 is hereby set aside. That's all. Anyhow, go there. The appeal is accordingly allowed.
My lord, whether it should be remanded back to the trial court so that then I will contest this airship, and even if I challenge the subsequent one, the first one, my lord. So both of them
The
may
first
be,
one has to be challenged.
yes. It may be remanded back at least, my lord, so.
If it was together, it would have been okay. But when you come, it will come. Whoever goes, why should we remand it? Whose is earlier? Whose airship is earlier?
My
her
airship is earlier, my
airship
lord.
certificate, my lord. So even if I challenge that, suppose it is also set aside, then the first
You
one.
just said
will be-
the issue of airship amongst the parties should be considered by the learned trial court after issuing notice and allowing both the parties to contest the issue on merit.
Yes, ma'am.
That's all. Okay. Both of you are, why didn't you challenge his airship there?
Now it's almost ready, my lord, for filing.
He's challenged it before, and yours will be how many days delay? 800
Maybe it's same
something.
thing with the present one.